All right. Hello, everybody that is watching online. I'm Deidre Martinez, the CEO of the Sheboygan County Chamber of Commerce. Thank you so much for joining us. We've got lots of folks in the room with us as well. And we are going to spend this last hour together talking with our Circuit Court Judge branch candidates for both Circuit Court Judge candidates for both Branch 2 and Branch 5. So I'll just quickly go down with names and then I'm going to give them an opportunity to introduce themselves a little further. Just as a follow-up, everybody's got 2 minutes to respond. We do have a timekeeper in the space. And we're just going to have a wonderful hour of learning about each of you wonderful candidates. So this evening, we have got our Branch 2 candidates, and I'm going to make sure I don't mess this up, Sheboygan Area Municipal Judge Natasha Torry and former prosecutor Jim Haasch. If you guys want to maybe raise your hands so they know who you are, just in case they don't know your faces. And then for running for Sheboygan County Circuit Court Branch 5 is attorneys George Limbeck and Cassandra Van Gompel. All right. Incumbents in both of these branches are not running for re-election. So just to give all of you guys an update on that. So with that, safety is a key element in successful communities. So we are going to hear from all of you guys about your legal experiences and your views on justice. So to get us started, Jim, if you'd like to give us an introduction of yourself.
Sure. Good evening, everyone, and everyone on Zoom. My name is Jim Haasch. A little bit about my background. I graduated in 1984 from Marquette University, cum laude, with a major in German language and literature and a minor in English. I then graduated in 1987 from Marquette University Law School and began my legal career here in Sheboygan in 1987. From 1987 to 2019, I was an assistant district attorney here in Sheboygan County, handling complex legal matters in the criminal courts of Sheboygan County. After that, I went to the city attorney's office from 2019 to 2022.
Thank you so much. And Cassandra.
Good evening. My name is Cassandra Van Gompel and I'm running for Branch 5. Anyone who knows me knows two things about me. One is that I'm committed to the community, and the second is that I'm committed to following the rule of law. I was a 2020 Athena nominee here from the Chamber of Commerce, and I thank your chamber for allowing us to speak to you today. I have been focused on improving Sheboygan County. I have been partnering with local nonprofits and businesses the entire time that I've been living here, and I've been committed to improving our community. I'm also committed to the rule of law. I have volunteered with high school, college, law students, and young lawyers, training them on how best to apply the rule of law. I have brought numerous attorneys to the areas that I've been practicing, and I want to do the same here in Sheboygan County. As Circuit Court Judge, I think I can do that, and I will do that, because I think it's important that we bring new people to the Sheboygan area. I think that we need more lawyers to practice all types of law in this area, and as I've been talking to all of these law firms, they are desperately looking for attorneys. Taking advantage of different internship opportunities and different apprenticeship opportunities, I think we could really grow this county, and as your judge, I would like to do that. Thank you.
Thank you so much. And George.
Hi, my name is George Limbeck. I have been an attorney in Sheboygan County for a little over 36 years. I started in September of 1986. My office and my practice have always been based in Sheboygan County. I started in Ram Lake. My office moved to Sheboygan, the city of Sheboygan, in 1990, and it's been in this county and this city ever since. However, I have, over the 36 years, practiced in over 30 counties in the state of Wisconsin, which has afforded me the opportunity to interact with many different lawyers, many different judges, see how things are done in different counties. And I think that that is something that will help me improve the court system in Sheboygan County. I have lived in Wisconsin since 1976, primarily in the Oconomowoc area before I went to college in St. Paul, Minnesota, and then went to law school in Washington University School of Law in St. Louis, Missouri, before starting my practice, which, as I said, has always been from day one in Sheboygan County and the city of Sheboygan.
Thank you. And Natasha.
Hello, I'm Natasha Torry, and I am running for Sheboygan County Circuit Court Branch 2. This is a position that's being vacated by Judge Kent Hoffman. I felt compelled to run for this position because I've been committed to our community, and specifically, especially while on the campaign trail, I've been hearing a lot about concerns about mental health, particularly with children, and that has been a big focus of my career. I started out representing children that were abused, doing all GAL work at the Legal Aid Society of Milwaukee, and then transitioned to Sheboygan County, where I worked for 11 years doing mental commitments, guardianships, and child support enforcement. I had my own practice called Rooted Law for 7 years, where I had a focus on family law that included guardian ad litem work, and eventually mediation, because I felt like that was the best way to assist families, was to try to have families come together to work out their issues instead of having only judges make major decisions in families' lives that are sometimes best left to the people that are actually living the situation. And I was elected to the Sheboygan Area Municipal Court in 2015, where I have served for the past 8 years. And I spend a good portion of my time there handling truancy matters, and which often encompass mental health issues. So even recently on the campaign trail, that is the most common issue that comes up, is people expressing to me that they have a concern about mental health issues in our community. And I believe that as a circuit court judge, that I would be able to have more tools to address them than I'm afforded currently at the municipal court.
Thank you. All right, so first question, and Cassandra, we'll start with you. Judges are elected as nonpartisan, but leanings of either conservative or liberal certainly come into play. Where do you consider yourself along these lines?
I really don't consider myself along these lines. I really am not a political activist, if you would say. I'm obviously following politics. I stay educated on all of these matters. I do have opinions that I personally hold, but I don't think that that affects my ability to serve as a judge. I think that as a judge, you really need to listen to the facts of each case and the law that applies in each matter, and you need to apply those facts to the law. In political situations, if you are affected by your politics, then you are not serving as a good judge. I am someone who wants to look at each case and decide not based on my own opinions, but by what is right and just in that situation, and that's what I will do.
Thank you so much. And George, would you like me to repeat the question?
Please.
Okay. Judges are elected as nonpartisan, but leanings of either conservative or liberal certainly come into play. Where do you consider yourself along these lines?
I consider myself more of a conservative. I think the term I used when I spoke last time was pragmatic conservative. And it's important that you understand yourself and where you come down on issues, because it's impossible to separate who you are and where you come from your job as a judge. Yes, we should strive to apply the law as written by the legislature, but it's I think naive to expect a judge to be able to completely separate their personal, where they've come from, their views on things, and how they're going to be judges on the bench. I don't think you can completely separate the two. I think you can be cautious, and if you're self-aware of where you're coming from before you make a decision, I think that puts you in the best position to make the right decision. Again, we all bring who we are to the bench, to our jobs as lawyers, teachers. It doesn't matter what your job is, who you are, where you came from, how you believe about politics and a lot of other things is going to affect how you do your job. And if you've got to be able to self-aware about that, you've got to understand what made you who you are in order for you to do your job correctly. So I am conservative, but I think that I know how to, I'm aware of where I come from. And so that when I make a decision, I'm going to apply the law, recognizing where I'm coming from.
And Natasha, would you like me to?
No, I can answer that. Thank you. Well, I would say that I'm strictly and intentionally nonpartisan, and I think that's important and required. Wisconsin is one of 17 states in our country that has specifically said that at all levels of our courts, we are to be nonpartisan. And the reason for that is because people are not supposed to feel that they're going to be treated differently or potentially have a different outcome in their case, depending upon what party the judge might belong to. And I have been very intentional in my position as a municipal court judge to make sure that people feel comfortable and never feel that I will be biased against them. I want every person that comes in front of me in my court to have a feeling that the decision's not made, that I'm going to listen to what they have to say that day, listen to the facts that come before me, and then make my decision. And any personal opinion that I have has nothing to do with it. And I think that's why I've been able to have such great bipartisan support in my campaign, because others in our community know this about me, trust my ability to be nonpartisan. And know that public safety is what's most important. And so that's why I have been endorsed by our police chief, Chris Dalmagalski, by our sheriff, Torry, by Judge Kent Hoffman, who's vacating the position. And he specifically said, I quote, "When I announced my retirement from Circuit Court Branch 2, I encouraged high quality, ethical, and skilled attorneys to seek the position. I've known Natasha Torry for years, and I'm proud to say that she exceeds in all these qualities, and she'll apply the law as written. I strongly endorse her as the next Branch 2 judge." And I appreciate that confidence, and I would never want to destroy that by portraying at any point that I have some political leanings one way or the other.
Thank you. And Jim, would you like me to repeat the question?
No, we're good. So in regards to my philosophy and who I am, those things have to get checked at the door when you go into the courtroom and when you put on the robes. A judicial mind is very much like a parachute. Neither one is effective unless it's open. And when I look at the position of being a prosecutor, case law has indicated that prosecutors are sworn ministers of justice, that we are just simply not to garner convictions, but we are to see that justice is done. In 31 years of practice as a prosecutor, I have made sure that I followed that doctrine very closely. I was as much concerned about making sure that truly innocent people did not come afoul of the criminal justice system as I was of making sure that those who needed to be held accountable were held accountable. What do I bring to this position? I bring neither the conservative nor necessarily the liberal viewpoint. I bring common sense values. And common sense is derived by experience, being in the trenches, being in the courtroom for 31 years, seeing different attorneys, seeing different judges, seeing different situations, spending thousands of hours, literally, in the circuit courts of this community. I bring common sense because, quite frankly, when you have lived a certain number of years, you develop common sense. And there's a reason why that people are called wise old person or wise old man. It's because you've lived for a period of time. You've experienced things. And I would bring that common sense approach to the circuit court of Branch 2. Thank you.
George, we will start with you this round. Older teens and young adults make up a substantial number of cases showing up in circuit court. Some say alternative sentencing for this age demographic both helps the offender and eases the burden on our system, while others believe sentencing should be tough. Where do you stand?
It depends on the person. It depends on the defendant or the juvenile that comes before me. If someone in that age group or any age group comes before a judge and has no prior history of being involved in either the juvenile justice or the adult criminal justice system, you can treat them one way. If someone in that age group, and it's not uncommon, unfortunately, where they have a long history in the juvenile justice system and or the adult criminal justice system, you're going to treat them differently. You have to judge each person on their case. And you have to make a determination in conjunction with input from the defense attorney and from the prosecution attorney and from the defendant or the juvenile themselves. You have to make that decision on whether you're going to lean towards, you're going to rule in favor of something that's going to allow them to move on without having a significant record, or if this is the kind of person that needs a harsher touch than someone else. So it's not a question you can answer, I don't think generally. I think it depends on each defendant or juvenile that comes before you and who they are as a person, where they've come from, and that tells you which way to go, or helps you to decide which way to go.
Thank you. Natasha, would you like me to repeat? Okay. Older teens and young adults make up a substantial number of cases showing up in circuit court. Some say alternative sentencing for this age demographic both helps the offender and eases the burden on our system, while others believe sentencing should be tough. Where do you stand?
Well, one thing that I have found in my capacity as an attorney is that expungement only being allowed for people that are under 25 or under is an issue because a lot of people just don't know about it. And we could use expungement laws a little bit more than we do. I think that it also should be considered that as a judge, we shouldn't be working in a vacuum. We should be working with multiple players. We should be looking at what is the prosecution recommending, what is the story of the defendant? What are the reports saying in terms of the appropriate penalty? And it reminds me of a movie that was shown at the John Michael Kohler Art Center recently when Claude got shot. And it was a story about a man who came to Milwaukee for a family reunion and or a high school reunion, and he got shot by a young offender who was 15. And it started out where the young man was in the children's court or in Wauwatosa, not being tried as an adult. And he was given multiple chances and it just didn't work for him at that time. And then eventually the judge had to make a decision that he be tried as an adult. But later on, there was a piece of restorative justice where the victim eventually was able to come to the prison, work with the defendant, and it didn't maybe make a difference in the sentence, but if the end goal is public safety and bringing the community back to a whole, I think that was on track. That was something that was on the way to being achieved. So I agree that it should be individualized. I agree that we should be looking at recommendations of all the players involved. But the end goal should always be what can we do to bring the community back? How can we restore both the victim and how can we rehabilitate the defendant?
Thank you. Jim.
In regards to this, I firmly believe in holding people accountable. As a father of 3 and a grandfather of 4, I have dealt with certainly individuals of the teen years, and they can be trying. Right now, the age for adult in the criminal justice system for being prosecuted is 17. It's 16 in regards to traffic offenses. I believe that the 3 criteria that we are called upon to fashion a sentence, the nature and gravity of the offense, the character of the defendant, and the need to protect the public, and subsumed under that criteria is the needs of the victim should be looked at in particular cases. When we talk about juvenile cases, those are somewhat different than adult cases from the standpoint that oftentimes in juvenile cases, the standard is what is in the best interest of the child, depending on the age of the child. As they become older and get towards the adult court and the adult system, I certainly believe in holding those individuals accountable. When I was an assistant district attorney, I relied on a lot of information in pre-sentence investigations that are garnered by probation agents. I relied on social workers and their reports to assist me in making a recommendation and coming up with a decision. But I have not hesitated when I thought it was warranted based on those 3 primary criteria: the nature and gravity of the offense or offenses, the character of the defendant, which includes his or her record, and the need to protect the public, that I have recommended very strong and very stringent sentences, and I would not hesitate to do so as a circuit court judge in branch 2 if I felt that was necessary to protect Sheboygan. Thank you.
Cassandra, would you like me to repeat?
No, thank you. I think that all options should be available. And as circuit court judge, I would dole out punishment when required, but hope when needed. I think that the law tells us that we are to look to probation first, and I think that that is important because the law is acknowledging the fact that most people with some supervision and guidance, especially young people, can benefit and can improve their lives. I think it's also important that expungement is available for those young people, and I do think that that is a good idea for first-time offenders. As far as different programs, there is diversion programs that some DA's offices do, and I'm not going to get into that because that's not the judge's role to tell the DA's office how to handle those types of cases. But if the DA's office were looking forward to that, I would obviously not interfere with that. I also think it's important to look at evidence-based programs. A lot of people are driven by what they see in the news, but we need to see what works and we need to do what works. It's not worth pouring our money into programs that are not going to be effective and accomplish what we are seeking to do. I know that Brown County actually has a young person's court. So if that was something that the community was looking for, I think there is already that kind of outline for us to look into. And if it has been working and is effective in that community, and again, you could get the community partners on board, I think it would be something that I'm open to. But again, that needs to be driven by the community and by the evidence, not based on emotions and reactions.
Thank you. And Natasha, we'll continue to talk a little bit more about teens and young adults. What do you believe to be the root causes for the high numbers of juvenile offenders? And what changes do you believe the court system can make to reduce these numbers?
Well, as the municipal court judge, I've been observing an increase in truancy dating back to even before COVID. And been attempting to track this and try to partner with the school district and different players, including social workers, teachers, the police. And what I have repeatedly heard reported to me from families and students is that there is a mental health crisis among children in our community. While on the campaign trail, I was able to participate in several events, including a mental health fair for the Howards Grove School District, as well as meetings with social workers for the Kohler School District. And they both recently completed a survey of the students regarding their mental health. And both Howards Grove and Kohler's results pretty much mirrored each other. And in a report that about 60% of the kids were reporting that they had experienced depression in the past year. 30% indicated that they had suicidal ideation, and then 8% had a suicide plan. So I would, without getting into each individual case, I would think that there is perhaps a mental health, untreated mental health component that's occurring that could be leading into other areas. And so as a judge, I would be looking at how can we beef up some of our juvenile justice measures? How can we make sure that our human services department is working and involved as much as possible in our young people's lives, in schools and in homes on a voluntary basis before they get to the point of needing to have criminal court intervention.
Thank you, Natasha. And Jim, would you like me to repeat the question?
No,
Okay.
thank you. I believe that a lot of the home life of individuals is a direct cause of some of the problems that we see in juveniles and young people in our society. There are socioeconomic things that put pressure on these families. Many times there are one parent who's trying to make ends meet and is working very hard, and the kids kind of fall between the cracks. I think that schools are a good place to educate our children. It's a opportunity for us to get mentors into the school system. In regards to the mental health crisis, the problem with one of the mental health crises axes is accessibility to it. If you've ever known someone who has had a mental health situation or an issue, just getting in to see somebody can be a several week and a month-long wait unless they're in absolute crisis, in which case, they're taken in immediately. But I think we have to make access much easier and more affordable in regards to the mental health situation. Organizations such as Big Brothers Big Sisters, Boy Scouts, Girl Scouts of America can act as great mentors for individuals. I've been involved with Boy Scouts of America for over 20 years. And I can tell you that I've mentored some wonderful young men who really did not have much of a home life and didn't have a father figure, and they found it in organizations such as this. So I think we as a community have to come together in groups such as that, help mentor people. Thank you.
Thank you, Deidre. As someone who works with high school students, I have experienced some of these troubles firsthand. I volunteer through the YMCA's Youth in Government program, and I actually brought a group of 12 kids to Madison just a few weeks ago. And I think that what they have found to be helpful is having that meaningful adult connection. Having someone who's actually asking them how their day is and having some sense of autonomy in themselves, that their decisions matter and their decisions have consequences. So I think that if we can improve some of these adult connections, that will really help the youth in our community. Some of the things as judge that I would like to do is bring back Law Day or Constitution Day, an opportunity to allow the students to come into the criminal, or not criminal court, but come into the circuit court and actually experiencing positive interactions with judges, positive interactions with attorneys, positive interactions with other people in the community, and seeing that there are these types of outlets available. Also, I think that mentorship is important. I've been to different Big Brothers Big Sisters events over the past few months, and I've been a longtime supporter of them with their Bowl for Kids' sake. I think that those types of programs are important, and they do have a large wait list. I think about 180 a wait list, and a lot of them are boys. So I think as judge, we can really look at some of these great community options that we have and try to help people take advantage of them, really bridge the disconnect between the people who are offering the services and the people who need the services. And I think as judge, I can help educate people on how to do that, and also use my capacity in this leadership role to continue to reach out and continue to do those types of things.
Thank you. George?
Jim, please reread.
Absolutely. What do you believe to be the root causes for the high numbers of juvenile offenders, and what changes can the court system make to reduce these numbers?
The consistent pattern that I've seen over the years always gets back to parenting and their young years. Everything we've talked about here for our children, mental health issues, the disconnect issues, I think gets back to parents doing a good job of creating a good family life and spotting when there are problems that need to be addressed, maybe even professionally, and spotting that early on. I have a son who is autistic, and so I understand how early intervention greatly helped him in improving to be the best person that he could be. And I also worked on Mental Health America in Sheboygan County on their board of directors for 3 years. I was president for one of those. And so I was intimately involved in making sure that people in Sheboygan County, we did everything we could to improve access to mental health services to all ages. But for children, client after client after client, and PSI, pre-sentence investigation report after pre-sentence investigation report, inevitably it gets back to, so much of it goes back to their childhood and what kind of a relationship they had with their parents, what kind of a relationship they had with their extended family. And that bleeds off into how well do they do in school, or how poorly do they do in school, how well or poorly do they interact with other children and other people. And those things in the wrong situation just explode into the problems we've seen with our young adults and our teens.
Jim, we'll start with you. Democrats in the legislature want to do away with the state's cap bail system, which they say costs more money than it's worth. Republicans, however, want to toughen the existing bail laws, especially given that several high-profile cases of late were tied to offenders that were out on bail. Where do you find yourself on this issue and why? And lastly, how would you advise the legislature?
Sure. So I think the way that you answer this question is you start with Article 8 of the US Constitution, which basically says that you should not impose excessive bail or cruel and unusual punishments. Now, what is excessive bail? Well, excessive bail is determined by what type of case you have in front of you. You have to look at the facts and circumstances. I think that the criminal record of an individual is fair game from this standpoint, that if a person is not willing to follow rules in regards to past offenses, what makes you believe that he or she is going to be following the rules in regards to a bail situation? I think that what I advise the legislature of is that you need to look, I think, basically at similar criteria to the sentencing criteria, the nature and gravity of the offense, the character of the defendant, the need to protect the public. And I would add another one to that, the likelihood of the defendant to respond to the conditions of bail based on all those factors. If you take a look at that, I think you can come up with a reasonable bail situation that will not only protect the rights of defendants in not having excessive bail, but also ensure that the community is safe. Bail is not meant to be necessarily all punishment. Bail is designed to ensure that a person shows up for their court hearings. However, that does not mean that that is the sole purpose that it should be used for. But like all things, you have to lay out in statute what you can and cannot consider.
Thank you. Cassandra, would you like me to repeat?
Yes, please.
Okay. Democrats in the legislature want to do away with the state's cash bail system, which they say costs more money than it's worth. Republicans, however, want to toughen the existing bail laws, especially given that several high-profile cases of late were tied to offenders that were out on bail. Where do you find yourself on this issue and why? And lastly, how would you advise the legislature?
So that's the second part, answer the second part first. I don't think it's a judge's role to advise the legislature. I think it's the legislature's job to come up with the laws. If the legislature is asking a judge how it's affecting how they work, I think that that's an appropriate time. But I don't think that it's appropriate for a judge to tell the legislature what to do. I think that they are completely separate roles and they should be kept separate. I think part of the issue with cash bail is it's the innocent until proven guilty aspect and the safety of community aspect. And I think that to some extent, cash bail, by increasing cash bail, really just keeps people who can't afford it in custody and lets people who can afford it out of custody. It doesn't actually protect the community. It just means if you have more money, then you will be out of custody. And so I think that there are other things that could be considered. For example, some non-monetary conditions of bond, GPS, ordering no contact orders, absolute sobriety orders, requiring people to take UAs. Sheboygan County has done a really good job of this with the day reporting program that's available to people so that we are not keeping people who are indigent or unable to afford in custody just because they've been charged with a crime, which sometimes they ultimately are not committed. It's found that they did not commit. So I think when we're looking at the cash bail system, I think that's some of the concerns. And I think that really that needs to be addressed by these non-monetary conditions more so than adjusting the cash bail.
George, would you like me to repeat?
No. The problem with the bail bond statute as drafted is it does primarily, the primary job of bond is to ensure the appearance of a defendant. If I were to advise the legislature hypothetically, I would tell them that they should have three primary considerations. They should have three primary considerations. First is to ensure appearance of the person in court. But secondarily, I think as in crimes of violence, domestic abuse cases, I think that a And given the constitutional amendment, which gives victims of crimes now constitutional status and constitutional protection, I think that protection of the victims, any victims in the case, could be a second. And finally, third, I think that the third criteria should be to reduce the risk of recidivism while out on bail. And so I think that right now, judges are bound by the law. And the law says the primary consideration is to ensure their appearance. And there are other secondary considerations we can consider. But I think we should start out with taking into account the new constitutional amendment protecting victims' rights. I think we can take into account the recent, it seems rash of high-profile crimes committed while they're on bond by adding those two, and then allowing judges, and our judges do a very good job of using alternative to cash bond when appropriate and imposing, I think, cash bond when it's necessary. And I think that the statute can be fine-tuned to help them do an even better job than they're doing. And people have to remember that if you're going to if the cash bond system or bond system is changed dramatically, you might very well be increasing your taxes to pay for more jails and more places to house people. So it's a balance that we have, that the legislature needs to undertake.
Thank you, George. And Natasha, would you like me to repeat?
No.
Okay.
Right, so this is one where it's a little harder to come at the end because I don't have anything new to say. And I think it's interesting that this is one where we probably all agree at the base level. So again, the bond statute, what the court is told is that it's supposed to be used to make sure that defendants come to court, that they show up for their trials. And that yes, we can consider public safety. And I agree, in Sheboygan, we have leaned heavily on some alternate methods. We really are depending on electronic monitoring. That is why just last year, our Sheboygan County Jail put an addition on where they could expand having people, not be in jail, be out on bond, but they would come in and they would get drug tested, and there would be fewer people that have to be employed to watch defendants, and that if we would have to have everyone in jail on bond, that it would cost a lot more money, that we would have to build a new facility, and it's not something that people necessarily get excited about, is to pay taxes. So we always have to look at what is the goal, and how do we get there in the most efficient, effective way. I think that we do have to recognize that if you have a system that uses money as the way to have access to justice, then you're going to disproportionately affect poor people. And as taxpayers, as humans, as people that are active in our community, we should have a problem with that. We shouldn't want disproportionate access to justice depending upon how much money you have. So that's a concern.
Thank you. And Cassandra, we'll start with you. How could the cost of judicial administration be reduced? And can you give us any specific examples of how you have reduced costs in your law practice?
Okay. As far as how judicial costs can be reduced, I think that a lot of it has to do with efficiency, honestly. Judges need to look, you're managing a lot of things. Not only do you have your own calendar, but you're also going to judicial trainings. You're also attending judges meetings. You're also getting asked about how to improve the community like we are today. And I think as judge, one of the things you can do to reduce costs is by trying to be more efficient, trying to make sure that attorneys are not coming in to your courtroom multiple times in either a month or a year with nothing to report. So I think there are some creative solutions that we could have, maybe more status letters. I know I've practiced in other counties that have done this. For example, Green Lake County has a status letter that says, I received discovery, I received an offer, this is what I would like the court to schedule it for. That saves a lot of time on the judge's calendar. And on top of judicial costs, it saves costs for either the public defender's office or the DA's office. And in family law cases, it's saving the dollars of the clients from the attorneys going into the courtroom. So I think that that can be addressed. As far as what I have done in my law practice, I have been employed for the State Public Defender's Office. And I can tell you, they have cost reducing measures. We are funded through the state of Wisconsin. And so we need to look at how we can make our budget go as far as possible. I'm actually the manager of a public defender's office that oversees 2 counties. So I'm someone that needs to be concerned with how many people are going to trainings and at what time. So I think that I've been able to run a law practice on a budget, on a state budget, and that's what I would do as circuit court judge.
Thank you. George?
The judges would make, they do need to be more efficient. There can be ways to make them more efficient. And I think that one of the ways is to further increase the use of digital remote devices such as Zoom, and other counties use different versions of Zoom. It can help to increase the efficiency by allowing more to get done in less time. It also saves the taxpayers money, because to the extent that an attorney in a criminal defense matter might be court appointed, which comes out of the county budget, or appointed by the State Public Defender's Office that comes out of the state budget, it's more efficient to have them appear remotely than it is to have them come in person. I would bring I've basically created my own business from the ground up, starting in 1990. I was an associate of someone for 2.5 years. I learned from him, and then I built my own business from the ground up. And I've been a solo attorney for most of my 30 of my years. And so I've always had to keep an extra tight eye on costs, because I have to pay my own bills. It's my work, and I am the generator of revenue for that feeds my family and pays my employee, and just keeps the business running. And I would bring that eye to being a judge, and I think it's a unique experience to help our judicial system become more efficient.
Thank you. Natasha?
I think that the number one way to promote judicial efficiency is just to keep the cases moving. And so sometimes that would mean just having a calendar, having expectations of parties and counsel, and sticking with it. I think it could be really important to encourage mediation, to have a system where people are encouraged to try to settle things outside of court as much as possible. I think that as a judge that it is a good thing, and it's something that you can do to give parties and counsel an idea of how you might rule in a certain case if the facts are a certain way, to maybe encourage some type of settlement ahead of time, ahead of coming into court. And that doesn't mean that you're necessarily prejudging a case, but I've been in front of many judges in different counties who have been willing to take both parties in chambers, listen to the case a little bit, and just give a heads up what could happen. And so that can help keep a case moving. I've had to be very efficient at the municipal court. When I first started, there was a lot of extra trial time that maybe wasn't the best way to use resources, and we were able to reduce from having 8 trial days a month to 3. We were also able to implement the technology that was mentioned, so that attorneys could appear remotely, by Zoom, by phone. Remarkably, that wasn't even there when I first started, and that does help not only have attorneys be willing to appear, but be able to appear quickly. So that combination of efficiency and then communication, just making sure that all the players are talking. I think that wastes a lot of time too, when the system isn't talking and communicating with each other.
Jim?
Absolutely encouraging dialogue between the attorneys. When I was a district attorney and when I was a part-time assistant city attorney, working in the circuit court and the municipal court, a lot of work gets done the attorneys outside of court picking up a phone and talking to one another. I would strongly encourage that as a sitting circuit court judge. And we have things such as scheduling orders, which are in effect now, but when people appear before you, particularly on complex cases, the way that you control things is you indicate, okay, this is a date by which motions need to be in. This is the date by which motions will be heard. This is your trial date at this particular point in time. And then as the parties work through things and get through discovery, some of those dates may change, but you would have to have very good cause for granting adjournments. When I was an assistant district attorney, I handled dozens of cases that had to get through 5 courts, in this particular jurisdiction. And you got to get on the phone, you got to talk with people. The other thing is, I think that mediation is a great way of doing things. It's a way of taking the cases that, people are kind of close on, but there's this one sticking point, and it can save, it can save a lot of time in circuit court. So I think those are the ways that I would do things. Also, when I was an assistant district attorney, I had to be cognizant of, this is taxpayer money that I'm using here going into court. And I did not file frivolous cases for a number of reasons. And I think that was also a consideration that I looked at when I was doing it.
Thank you. We have time, see how many more questions I can ask. All right. So George, right, George, yes, okay, I'll figure it out. Better that I mess it up and not you guys, right?
Right.
Okay, so next question, what do you perceive as the greatest obstacle to justice, if any?
Staff shortages, period. Right now, at least, right now, we have a DA's office that is rated at 9.5 attorneys, and I think they have 4.5. I can't tell you how much time, this gets back to the efficiency question, how much time and money has been wasted because we can't move cases forward because the district attorney's office is there. They got 4.5 attorneys handling a caseload for 9.5. The shortages of defense attorneys, the public defender's offices, I get 2-3 emails a day from Price County, Marinette County, Racine County, Southwest corner, all over the state. And they've contacted hundreds of defense attorneys, and there's just a shortage of criminal defense attorneys and juvenile attorneys. Right now, that is the biggest obstacle to running an efficient court system. And and so that's the first thing that's going to be fixed, and that can only be fixed by the legislature. There's, other than whatever persuasive power we have with our legislators, to legislative members to budget the kind of money that needs to fix this problem. With judges, we can appoint in certain cases an attorney, or if we, assuming we can find an attorney that's willing to take it at court appointed. But right now, the biggest obstacle is that. I think the second biggest obstacle in Sheboygan County is bringing the technology up to date compared to a lot of the other counties I practice in. They're way behind.
Thank you. Natasha.
Well, I think that most of us are familiar with the concept of the right to counsel for criminal matters, and that was established with a Supreme Court case called Gideon versus Wainwright. And so that provides that we have the right to counsel, and that if we can't afford it, that then the state would cover that cost. We don't have a civil Gideon. So there is no right to counsel in a civil matter. And there is the ability sometimes for judges to appoint, but it's not required. And what I think is the biggest obstacle is that we have people that just aren't aware of what their rights are, not aware of what the law is, and can't afford to hire an attorney. But the court is not able to always, cannot actually give them legal advice, and isn't even always able to educate them on some of the finer points. And then we also have the situation that Attorney Limbeck mentioned that even applies in civil matters, that even if some of them could afford to hire an attorney, there just aren't enough attorneys available. And so I think that that's probably the biggest crisis is just lack of knowledge and lack of access, either due to finances or just regular availability. And so that's an obstacle.
Thank you. Jim?
There are a lot of obstacles, unfortunately, at this particular point in time. There are certainly the staff shortages that we have. To give you an example, when I first started in the DA's office, DAs were county employees, and the starting salary for DAs back in 1987 was $23,000. The public defenders at that time were state employees. There was a bill through the legislature that was signed into law in 1991 by Tommy Thompson that gave us parity with the public defenders. And that garnered more people staying in the prosecutorial field. Many times DA's offices as county offices became proving grounds and stepping stones for people who came in for 2 years, got some trial experience, and then they went off to private firms where they could make more money. Shortages are definitely a problem. The other problem that I see and saw more towards the end of my career than the beginning is just simple civility in court. We as litigators have gotten away with being civil to one another. It used to be that when I first started, I could call, John Smith on the phone, and I could say, John, we've got this case. What are we doing with this? Let's talk about this. And, I'd make a few notes. And when you got into court, you'd put the agreement on the record. John Smith would say, yes, that's what Haasch and I talked about. And you got things done. Civility is, I think, lacking nowadays in many areas. Those are some of the ways that I think are impediments to the court's functioning.
Thank you. Cassandra?
Thank you. I think the main obstacle is really access. Whether that's access to attorneys or access to legal information, I really think that is where we are at this point. As I indicated, I manage an office, and so I need to make sure that office is staffed. I have been able to add more positions. I've also brought legal interns into the area. And I really think that is important for a few reasons. Number one is it doesn't cost the taxpayers money. These internship opportunities are usually sponsored by the college or the law school that someone is going to. I've brought in someone from the University of Maine. I've talked to Rutgers about bringing in people. I mean, it doesn't need to just be the state of Wisconsin, but I have went to Marquette University Law School for their Public Interest Law Society auction and talked to the associate dean for public interest, and I've asked her to send me interns. I'm going to have an intern from University of Wisconsin during the summer. So I think that some of these opportunities are important because it gets people into the community, it gets people practicing law, it gets people comfortable with the judges. And as a judge, you can also have judicial law clerks. You can basically shepherd a young attorney and you can teach them about the law. And so I think that that's one of the ways that we can improve the shortage of attorneys. And as I indicated before, it's not just criminal defense attorneys. It is a lot of different types of areas. When I've been meeting with different law firms, there are literally empty offices in some of these law firms for people to try to get new attorneys in here. As has been indicated, the legislature needs to address some of these issues. I have attended the legislative listening session that was recently held at the Meade Public Library to hear what the legislative representatives had to say about this. And they do sound like they are going to address it. So I am trying to learn more about this. I'm trying to educate myself, and I'm also experiencing it firsthand with running a public defender's office.
Thank you. We'll do one more question, and then we'll give a chance for you guys to do some closing comments. So Natasha, what part or parts of your experience do you believe qualifies you over your appointment to hold the title of circuit court judge?
Well, I think that the first and easiest answer is the fact that I am a judge, and that being a judge is different than being an attorney. Being a judge requires a different skill set. It requires you to be able to listen to people without thinking about the next thing that you're gonna say, and actually be prepared to respond if necessary, but to listen in just a way that's different than what you do when you're an attorney. And that's something that I've been able to develop over the past 8 years. I have that experience of managing a courtroom. I have that experience of managing a court calendar. I have that experience of trying to find ways to be efficient. I know what it's like to show up regardless of how I feel, because there's a court calendar and there's nobody else that's going to be able to take care of it if I don't do it. So I think that that would be the number one easiest way to start. I think that I also have a very unique background, and that I have practiced in the nonprofit, government, and private practice sectors. I've practiced in multiple counties. I didn't have just one job. I've practiced in multiple practice areas. I am proficient in family law. I am proficient in guardianship and mental health law. I am familiar with housing law and employment law, and I've also represented some clients in criminal law. So I think that just having that vast background, practice areas, vast background of different settings, as well as being a judge, makes me the most qualified.
Thank you. Jim?
Well, it's important to remember the position that we are running for. We are running for circuit court, which is vastly different than a municipal court. In regards to the qualifications that we bring to the table, I've spent, again, 31 years in the 5 branches of the circuit courts of this jurisdiction under many different judges. And I've seen how different things work, and I've seen how different things don't work. In regards to what I would bring in regards to my qualifications is, you have someone in my abilities who can hit the ground running, who can begin trying cases without a particularly steep learning curve. Just because I was a prosecutor for 31 years does not mean that I was not exposed to family law situations. You have domestic violence situations where there's family law involved. I was not, you don't say that I wasn't exposed to mental health issues. There is a lot of issues in regards to not guilty by reason of mental disease or defect, where you had to go through psychiatrist reports and a lot of mental health issues. So, you know, to say that a prosecutor does not have these broad experiences is kind of a misnomer. I think the 31 years that I bring would make me able to hit the ground running without a particularly steep learning curve. That doesn't mean to say that in the areas that I would be somewhat lacking, say probate, that I wouldn't pick up the books and be studious. But you need someone who's in there who can hit the ground running and get things done right away.
Thank you.
Thank you.
Cassandra?
Thank you. I think what differentiates me from my opponent is that I have experience being a stakeholder in the criminal justice system. So as the manager of an office, you're often the representative for your office to the other partners in the community. So for example, as the manager of a public defender's office, I get invited onto multiple county committees. I've also been attending judges' meetings where things are determined basically how the courts are going to run. Many of the questions that have been addressed here today actually have to do with policy related items, and those things are addressed at judges' meetings. And I have experience going to those meetings and working with the DA's office, the registrar of probate, the judges, even law enforcement. I have served on the security committee. I have also served on the Child Needs Protection Services Committee. I have also served on the Criminal Justice Coordinating Committee, Drug Treatment Court Committee. I have served on all of these committees, and I think that really gives me a leg up because I'm already thinking about these issues on top of my law practice, on top of the cases that I'm having. And as judge, you have to be able to manage both of those things, the day-to-day cases, as well as the policy-related questions. I know that in comparison of quantity of years, I do not have as many years of experience as my opponent, but it's not the quantity of years, but the quality of work. And I have been working hard the entire time that I have been working as an attorney. I not only have handled criminal matters, but I've handled Chapter 51s, which are mental health commitments. I've had jury trials on those types of cases. I've handled juvenile matters, Child in need of protection and services matters. Termination of parental rights matters. And I filed all sorts of civil motions in those matters. And I think that that differentiates me from my opponent.
Thank you. George?
Age. There's some things you can't learn in a courtroom or just in a courtroom. There's not things that you can learn in any committee meetings. There's just the learning that comes with living. Second, I have my business experience in building a business from scratch, employees, revenue, costs. For 30 years, I've been solo. For 6 years, I was with a firm. I practiced everything. I've done jury trials and termination of parental rights. I've done jury trials in CHIPS cases. I was involved in a CHIPS case where the state tried to have a young lady inserted with a 5-year birth control pill. So I have civil experience. I've done family law. I've done disability law. I've done just innumerable different areas of law in my practice. So I think that it's age. I think the practicing in so many different areas for such a period of time, practicing all over the state, practicing with innumerable different people, and yet focusing on Sheboygan County, interacting with Sheboygan County residents, listening to my clients, listening to their families. That all over the years, you just start learning what the people of this community are like, what they want, where they want to go, where they don't want to go. And I think that is what really puts me ahead of the ballgame.
Thank you. Well, we're a little over time, but we'll go around the table. So Jim, what would you like to tell voters? Maybe anything that we've missed this evening?
How much time do I have?
We'll do 2 minutes.
Okay.
We're all here anyways. We'll keep them in the room a little longer.
So first of all, I'd like to thank the chamber for putting this forum on. I'd like to thank the people who showed up tonight in person. Everyone is very busy, and to come to this forum is wonderful that you would do that to give us an opportunity to speak with you. I'd like to say thank you to the people who are watching on Zoom. I think that this is one of the most important closing arguments that I've made in my career, because I'm not advocating necessarily for a cause or for a case. I'm really advocating for myself. And the type of person that I would bring to this position is one who has a great deal of humility. I'm very humble, but I also think that I have the experience and the temperament necessary to be a good circuit court judge. As I indicated in one of the prior questions, I can hit the ground running. I can start trying cases and hearing matters right from day one. I would ask that you take a look at my website, www.haaschforjudge.com, for more information on my qualifications. I would ask for your vote on April 4th. Thank you.
Thank you. Cassandra?
Thank you. Similar to Attorney Haasch, I also agree. Thank you to everyone. I think that it takes a village to be interested in our justice system. And I really do think that it's important that you listen to what all the candidates have here to say. And I think it's also important to know that we all learn from each other. So as much as I think it's important that I am talking to you, either here in the room or on Zoom, I think it's important that we also listen to what other people have to say. I have a different experience than everyone else, and everyone else has a different experience than I do. And really, as judge, I want to be able to listen to what other people have to say and consider what they have to say when deciding what the best course of action would be. So as your judge, I will do that. If you are in the community and you would like to get a hold of me, my website is votevangompel.com. There is a comment section. I will go to your community organizations, and I have been doing that. I've reached out to the Rotary Club, the Kiwanis Club. I'm on some of your agendas coming up. And so if you are looking for me in the community, that's where I will be. I will also be knocking on your doors, so feel free to open your doors when you hear a knock on the weekend. And I look forward to really talking to you and also getting a chance to listen for once. So thank you.
George?
You know, I've been thinking about doing this, talking to colleagues, coworkers, friends. A lot of them are in the court system. I've been thinking about and talking about running for judge for probably 10, 15 years. I did not make this decision lightly. I didn't rush it. I waited until I felt I was in the best position from experience, knowledge, my ability to interact and work with my peers, and they work with me, before I made this decision to run for judge. And again, all I can say is I did not take it lightly. I really thought about it. I waited until it was the right time. And now is the right time when I'm in a position to give back to the community that has given so much to me over the years that I've lived in this county and worked in this county. Thank you.
Thank you. Natasha?
Thank you. Well, I am running for this position because it is important and it matters who is in this position. It matters who makes these decisions. This is not about me. It's not about my ego. It's about our community. And it's about stepping up and bringing forth what we need to continue to have Sheboygan be a good place to live. I'm not new to caring about important issues here. I have a demonstrated commitment of service. I have, for the past 20 years, been an active volunteer, both in the legal community and in nonprofits. I have and currently served on the board of the John Michael Kohler Art Center. I'm on the board of the Boys and Girls Club. I'm on the board of CASA. I have been our president of our bar association. I have served at the state bar level for the appointment selections committee and on the family law board. And that's because, again, I have this demonstrated commitment to our community and I care about what happens here. I think that we need to really take a step back and appreciate that judicial elections have an impact on all of us and not just people who come to court. We shouldn't wait until we're in the courtroom to care about who our judges are. We want judges who are able to listen to people, who are able to fairly make decisions, who are able to see outside of themselves. And that is who I am. And that is who I've demonstrated that I will be in the future, which is why I have the endorsements and support that I do have. And hopefully the vote of you today. Thank you.
Thank you. All right. Well, thank you all for coming. Thank you all for your willingness to serve in this space. I understand that it's not easy and I applaud you. And we really are appreciative that we have so many people that are so caring of Sheboygan County and what's happening in our space. And thank you all for coming and listening in. We are going to end the recording now, but of course I have to just give the plug. Make sure April 4th, if you haven't voted early, that you get to the polls and you vote. And if you have any questions, check out any of their websites and hopefully they will be able to answer those for you. All right, have a good day.
Register.
I do.
You got an email?
So I'm in the state.